So, Attorney, we can welcome you on your first appearance.
I wish to convey to your lordships that the government is very keen to pursue this matter. I have applied my mind on the review judgment and to various other challenges involved in reopening this matter. But having regard to the concern of the government that we cannot abandon the victims, so the tragedy is unfolding almost every day. So I would take a little time. I would have probably placed before the court my brief note of issues, but for want of time, which I could not do. But I'm sure that we'll be able to assist the court on this very, very challenging case where more than one aspect of the matter may have to be unraveled for the first time. So I've also looked into examples elsewhere, both in case of opening settlements and also mass starts, etc. We have a considerable literature when courts have gone into beyond the settlement arena. So I think I'll place all that material before the court whenever the court assembles again. But before that, I propose to share with the court my brief note of issues I thought can be gone into by the court. The Lordship may go through it with circulation, in not assembled in the court. At a later point of time, by the time we would have assembled all our materials, our convenience volumes and compilation of judgments, etc., we have a rich bibliography available on these issues. I will take a little time.
The government, you have to take a stand whether you are proceeding. You are saying you are proceeding. And but you don't want to proceed today, it appears.
Today it's only for direction. The Lordships wanted to know whether the government is keen to pursue this matter. I think yes.
How much time do you need for it? See, one, if you want, if you are proceeding with it, then you must have a separate. We don't want to take the whole record.
I understand.
A separate compilation. You must make a.
We will do that. We will
only look at the convenience compilation.
We will have a dedicated team for having that done.
From both sides. From both sides, you have to have a dedicated team to make the convenience compilation. Do your housekeeping task, and then only we listen.
I have a request,
My lords, we are.
What has happened is that, my lord, the victims, because we were there in the forefront, my lord, when the tragedy occurred, that is Bhopal Gas Pirit Mahila Udyog Sanghathan and Bhopal Gas Pirit Sangharsh Udyog Samiti. We were in the forefront, my lord. We came before this honorable court, even for distribution of food, interim leave to be given. Then we filed a review petition. It was on our review petition, my lord, the judgment came. Now, thereafter, my lord, we raised the question, even before this curative petition, that the compensation which has been given has to be increased. My lord, that SLP is pending here, which, my lord, lordships are directed to be taken up after the constitution bench decides. Now, my lord, in one case, my lord, set of victims, lordships have implemented them as parties, but we have not been implemented as a party.
We can't have this expanding notion now.
No, my lord, the question is, my lord, this. No, my lord, it will have a bearing on the fairness of the.
No.
My lord, the question. My lord,
Is your curative petition before us?
No. My lord, yes, ma'am.
Is your curative petition before us?
No, my lord, curative need not, because it is filed, my lord, parents.
We should select everybody who is affected.
No, my lord, it's like this. My lord, may I just point out?
My lord, support.
Why do you think the attorney is not capable of looking after?
No, my lord, it is like this. My lord, may I just point out? We will be committing a mistake, my lord, which we committed earlier, because, my lord, we were not heard. And then the settlement was arrived at. Now the question is, my lord, section 4 and 3 have been interpreted, my lord, in Charanlal Sahu. And what has been said is that ultimately we are necessary. My lord, the question is this, precisely. A organization which has been taken up this issue, my lord, from the beginning is not implemented. Organization.
How do you implement 100,000? You are one of.
No, my lord, we are there. No, we are there in the beginning, my lord. It is our petition.
My lords, on this issue, very briefly.
Our petition, my lord.
Sir, in your support. My lords, very briefly. We have petitioners 2 to 6, my lords, that where we are the victims, and orders have already been passed in 2011. My lords, what they are saying, there are 7 organizations altogether that represent all the victims. There are no other organizations. So we, my lords, are for 5 organizations. The impleadment has happened. We are now parties. So my lords, what they are saying,
By which order were you made parties in this?
by 13/4/2011, my lords, they are saying, if I may just finish, then of course you
My
have your
question is
chance.
very specific.
Yes,
In
sir.
the curative petition,
My lords,
who is the party?
in the curative petition, I am a party.
Impleaded.
But it's been allowed, and then it has been said that on maintainability and merits, we will be heard.
We will not permit, I've discussed, we will not permit it like this. We are not averse to hearing a point of view. Yes. But we will not let parties be intervened like this. This creates a unmanageable situation.
My
So I
lord,
have to say something on the basis of the records and previous before us. We are not averse to listening to you. No difficulty on that account.
my lords,
But we,
very well on their point, my lords, our petition is already there as it has been said. So my lords, if that can then be, if we can be heard on the next occasion, we have, along with everybody else or whatever,
But may
we
I-
are in my lords, we are already petitioners. I was only speaking up
May
with their
I
support.
not point?
My lords, I don't want to
No,
lose
it's not a
our
support
space.
actually, because the question is, my lord, for the victims. When we came initially, when Union of India had not filed, my lord, even the review petition, we filed the review petition. We have been, my lord,
what happened to your
ultimately,
review petition?
yes, my lord.
What happened to your review petition?
My review petition
Partially
was,
allowed.
no, that was allowed. And that's how, my lord, the judgment, partially, the settlement which was there, my lord, on that
In the
settlement, my
criminal,
lord, the
uh,
directions
that
are
is-
given.
that is-
And one of the directions is this, my lord, and that is where, which is
Has your
important.
review petition worked itself out or not?
Review petition, after review petition, my lord, we moved an application. Yes, my lord, sorry.
Has it worked itself out or not?
No, my lords, they are still
That's,
absconding.
my lord, they are
My
relying-
lord, respect criminal cases, and they are
They
still
are
proclaimed.
One second. They are relying upon, Union of India is relying upon the directions which are given in our review petition, which was filed by us.
Maybe.
And
I-
one
I
important
hope- I
fact,
hope
one
that's-
important fact I must point out, para 197, what has been said is, where, my lord, the in curative petition, the Union of India disputes that because they say, in case UCC is not able to pay, my lord, then Union of India will pay. Now, they ultimately, my lord, dispute that the finding which is given by majority is not correct. Now, we are not on that because ultimately it will be adjudicated, but I come in because it was in my review petition, a finding which has been given is being, my lord, questioned in this curative petition. So how do I, my lord, then come in?
No, no.
Yeah, that's how I come in here.
You are satisfied with the orders passed on your review petition?
That's what.
No, my lord, they are not.
What did you do? Did you?
Yes, my lord, yes, correct. What I did was,
Did you file a curative petition?
no, my lord, what I did was curative, my lord, jurisdiction came subsequently. We filed, my lord, an IA. That IA, my lord, lordship said you go before the adjudicating authority. We went before the adjudicating authority. Then, my lord, High Court, my lord, may I just finish? High Court, and then ultimately SLP, which is pending here on the same question. After our SLP came that they filed a curative petition. That's how it has happened. So, my lord, we have been pursuing, my lord, the cause of victims from the very beginning.
Yes.
Now, I leave it to your lordships, my lord. I don't want to say anything. I just want to, my lord, I have prepared the entire thing which we did. That we should be, my lord, we should be heard because of this reason, because if you are not implemented as a party, any direction which is given, because the direction ultimately has to be binding. And they said they are on our behalf. This petition has been filed by Union of India. They have said this is parens patriae because under section 3, my lord, the right has been given under section 4. The organizations have been given, my lord, the act which was framed after, my lord, after the tragedy happened. Under 4, my lord, we have been given a right to be represented. And what this court said that we committed a mistake in not hearing the victims. Though ultimately this was a little wrong, but for a larger purpose, we are condoning it. Otherwise, it will be a violation of principles of natural justice. In a larger sense, my lord, if we are not heard, then there will be, my lord, I repeat, my lord, it is the same kind of situation which happened then will be happening now. So, lord, I leave it, my lord, victims in lordship's hands to protect us. And, my lord, team, my lord, whatever is proper order should be passed. My submission is, my lord, these are the organizations which are there. We are there from the beginning. Not, my lord, come today.
As you said,
Yeah, my lord, not come today. So if, my lord, there are certain organizations
you
which are already implemented as
5
parties,
organizations.
we should be implemented as parties.
You represent 5 organizations. He represents how many?
2.
Precisely, my lord.
This is not a previous case, my lord, where the party which files a review does not come in curative. The Union of India does not file the review but comes in curative. That curative is filed after 19 years of passing of the review judgment. And my lord, the criminal curative petition was dismissed by my lords because it was filed after about 17 years on account of delay. Similar curative petition on the same facts was dismissed by my lord on delay.
My lords, greatest respect. This is Union Carbide. That is absconding.
Just wait.
Contrary to my
They were right to be heard. Yes.
Let's say, if I can, let's say. Now, let's in the order dated, the first aspect about the implement of these NGOs. 13th April 2011 order. The lordships have also raised the question of the maintainability of these implement applications. If a lordships will, my lords, please see that order. It's clearly said, my lord, the maintainability of the implement applications filed by the NGOs is an issue and has to be decided, my lords. Now, my lords,
Was that decided at any stage?
no. This hasn't been decided, my lords.
My lords,
Now, what happened, my lords? Since, my lords, the matter was in circulation and the notice was issued, my lord, it said that for open hearing in the court. My lord, the registry has allowed them to be pleaded, my lord, as co-petitioners, my lord, though the Union of India only has filed the curative petition. My lord, curative is an extraordinary, my lord's revenue that your lordships evolved in 2002. Well, the reason why, my lord, these NGOs cannot seek, my lords, an independent right for enhancement of the compensation, other than, my lord, Union of India subject to the merits, is, my lord, the provision of the Bhopal Gas Act, my lord, enacted by the Parliament, my lord, after the Treasury. The essence of the Lord Bhopal Gas Act is that the exclusive right has been given only to Union of India, my lords, not to the individual victims, not to the NGOs, my lords, or the organizations, but all claims in regard to the disaster, my lords, the exclusive right in regard to the damages to the person or the property or anything of the claim is with the Union of India. The constitutional validity was challenged in Charan Lal Sahu. Your lordships and a constitutional bench have upheld the act and saying that it's only the Union of India. So, my lord, NGOs today, my lords, and what is happening is applications after applications are being filed, my lords, papers after papers, documents are being done. And now lordships have a record of more than 5,000 pages. My lord, we have also filed an application, my lord, saying that these NGOs do not have, my lord, the right of impleement because of the act also, because of the order, and they should not be. This is one aspect of the matter, my lord. On the last date, my lords, when the learned solicitor, my lord, said that he would like to take instructions. The matter indeed came up for, my lord, directions, my lord, because the housekeeping has to be done, my lord, in this case. The voluminous records, compilations have to be prepared. My lords, the lordship said in the, my lord, the circulation that the councils have to indicate as to how much time. Short submissions have to be filed. Timeline has to be indicated. So, my lord, all these things have to be done. Our problem today, my lord, is this, that even yesterday night, my lord, tonight, a bunch of papers have been filed by the NGOs, my lords, which is quite unnecessary. The contest is between the Union of India, my lords, and the UCC, my lords. The lordships may, if the Union of India wishes to go ahead, my lords, we can't say anything. But he take the matter for housekeeping, my lord, give the directions, allow us. There are as many as 8 or 9 IES, substantive IES filed by them, my lord, for seeking enhancement of compensation to some, how many crores, I don't know, 20, 30,000 crores. My lords, the notice has not been issued, my lords, how do you know those applications, my lords? If they have to be heard, then we have to give response. So the lordships may decide the issue of the maintainability, my lords, whether they can be co-included as petitioners in the curative petition along with the Union of India. They are virtually, my lord, trying to become co-plaintiffs. That's what
I just want to add, just one second, just to add to that, my lord. First, before the NGOs come into the picture, your lordship will have to decide, my lord, whether the jurisdiction of curative was not there at the time of passing the review petition, whether the curative petition is at all maintainable, number one. Number two, Union of India did not file a review. They were satisfied with the first judgment. Now, by skipping the review, whether they can file the curative. Number three, my lord, the delay of 19 years after passing of the review judgment. 19 years, 91 was the review judgment. Union of India filed the curative in 2010. And thereafter, my lord, as I said, my lord, criminal curative has been dismissed.
And
And
one
there are
thing-
so many other, my lord, maintainability issues of the Union of India's curative petition itself. Your lordship may be pleased to decide that first before coming into the issue of the NGOs. In my respectful submission, enough material to, my lord, dismiss the curative.
One thing, just 1 minute. One thing, my lord, which I forgot
Review
to,
was, my lord, decided in
Which
open court
which
after
I-
full hearing.
which I forgot to mention is this, my lord. In 99, it was a court negotiated settlement, my lords, by a
Yes.
constitution bench.
Correct.
470 millions, my lord, US dollars, which translated into 3,000 crores, my lords. 1991, my lords, a review was entertained by a constitution bench, my lord, presided over by his lordship, my lord, Justice Venkat Chalaya. Hearing went on for 88 days, and there were only two issues, my lords. One was the adequacy of the settlement amount, $470 million, and the second, my lord, where the criminal proceedings were quashed. The constitution bench, my lord, in the review petition decided that this aspect of the adequacy of the compensation cannot be reopened. It is adequate. If there is any deficiency, my lord, in future, Union of India will meet it. However, my lord, the criminal proceeding question was reviewed, and my lord, the criminal proceedings were restored. An attempt was made in 2007, again, my lord, for enhancement of the compensation by filing IAS by the NGOs. My lord, the bench of this court, my lord, said, after obtaining the affidavit of the Union of India, we say no need for enhancement. Welfare Commissioner, who is a presiding judge, my lord, said no need of my lord, enhancement. Dismissed that, my lord, substantive IA, my lord, that there is no, the settlement amount is adequate. As a matter of fact, my lord, I must tell you, lordship, out of the whole corpus of 3,000 crores, the settlement commissioner could distribute only 1,500 crores, my lord, to the eligible claimants, because there was just a law frame, my lord, for award of the compensation. 1,500 crores was in surplus. This law, my lord, this court in extraordinary jurisdiction directed that this surplus amount be also distributed on a pro rata basis to victims. So they have been paid compensation twice over, my lords, and still the amount is surplus. The latest figures in 2022 is that the amount with the RBI is still lying there, my lord, and is surplus.
They also, they have both rupee amounts which are left.
And
also
dollar amount.
Dollar amounts. I'm not, the issue will really be to supplement what my friends have said. Your lordship, when you frame the rules, say very specifically in the rules in chapter 47, you say that a curative petition shall be accompanied by a certificate to the effect that it is the first curative petition. So now the first curative petition, whatever its merit has been filed, we will have to argue it in our own turn on its maintainability. In effect, without filing a curative, the NGOs who lost out in the judgment reported, as my learned friend says in 2007, volume 9, SCC 707, now seek to ride on the wings of the union and come through a back door and then agitate their claims. Now that can't be done. And please see the order of 2011. There is, I'm sorry to say, it is an incorrect statement to make that their applications for impingement were allowed. A revised order came to be passed on the same day. The revised order made it very clear that maintainability has to be considered in those matters. And that revised order is part of the record. My learned friends cannot say they were impeded. That's not correct. So the registry has inadvertently done so.
My lords, if I may
Please see
briefly
the revised order.
respond to this
I'm
point,
by your-
beginning with the order, I'll read it out, my lord.
Read the
It
revised.
says, I didn't interrupt, sorry, if I may have just a couple of minutes. Interlocutory application numbers 7 to 9, these are mine, are allowed subject to service. Subsequent to that, it says, issue notice on the maintainability of the interlocutory applications and merits of the matter.
Because
So, my lords, the hearing that happened then, and in fact, in a lighter note, the Chief Justice was representing us in the criminal curative petition. Our interlocutory applications were allowed. And what was said was that subject to maintainability and merits of the matter. Because it was recognized, my lords, that these are inextricable. My lords, we had filed an application for impediment pursuant to the right given in Charan Lal Sahu, which is a 5-judge bench. they had looked at the Bhopal Gas Claims Act, Section 4, and they had said that, look, we can't make up for the fact. I mean, we can't unravel the settlement to the extent that you weren't heard prior. So now that's all done as water under the bridge. But now you must be heard. And what it says, and I quote, in order to make the opportunity contemplated by Section 4 of the Act meaningful and effective, it should be so read that the victims have to be given an opportunity of making their representation before the court comes to any conclusion. In addition, Section 4 says the central government shall have due regard to any matters which such person may be required to be urged. Now that the learned Attorney General has made such a heartening statement, we are deeply hopeful that they will have due regard to our pleadings as petitioners 2 to 6. But my lords, regardless, we have our claims before the court. My lords, there are two aspects of the review, as one of my friends very fairly pointed out. They said that, and this might narrow the issues a little bit, they said that there is the civil aspect, which is the $470 million, and then there is the criminal aspect, which was initially quashed. And then their counsel invited the jurisdiction of this court explicitly under Article 142, citing the Sanchita set of judgments, in order to say, please support, please continue the withdrawal/washing of the cases. This court considered that issue and said, no, we are not doing this on the basis of a public policy. We are saying because in this case, the matter must be investigated. Not in any regard did they say that this is without prejudice to the argument that they are not submitting to the jurisdiction of their court. And yet, the next day, Union Carbide said through their counsel, I have these documents on record. Union Carbide said that through their counsel that this court has no jurisdiction over us with regard to the criminal cases. 4 months later, and we have that on record, the criminal court concerned, the jurisdictional criminal court, declared them a proclaimed offender under Section 82. To this day, they are absconding. It is recorded in the final judgment against UCIL. And so with regard to the second part, my lords, there's no more delicate way to put it. We believe that they have played a fraud on the court. There was an order that was placed after that with regard to attachment, my lords, of their properties. What they did, and these are not my words, these are the words of a district court in Connecticut, a federal judge in Connecticut, their country, said that the admitted facts are that after the Bhopal gas disaster, they set up a web of intermediaries in order to bring their goods into the country. My lords, with regard to the settlement itself in 2009 and 10, through the process of RTI, but also the US discovery process, which is quite rigorous, and they're on pain of criminal penalties, documents can't be suppressed, etc. Documents were discovered showing that they had an internal report which says that methyl isocyanate, once inhaled, only causes permanent injury if you have been in it for, say, a few hours. They had proposed, and this is the basis of the settlement is a top secret document. And I quote, it says top secret right on top. With the government at the time, which proposed categories of temporary injury and permanent injury, and over 98% of the claimants have got under temporary injury on average of 25,000 rupees, whereas they knew that the injury is most likely in all cases to be permanent, and that was suppressed. How are we arguing suppression? And this all we will place, my lords. We are saying that they suppressed it on the basis that they told the the Environmental Protection Agency that this is a trade secret. We are required by law to give you these documents. Please do not disclose them further. But the Environmental Protection Agency decided otherwise. So, my lords, a recent 22 judgment, but all the way down from Chengalwade, as my lords are aware, fraud must unravel a judgment. Cannot sustain. And my lords will explain that 2004, not 2002, 2004, the curative jurisdiction arose and why we are coming in 2010.
And I'll take only 2 minutes. I'll not take minute because I already said minute. Number one is not saying NGOs may not be correct because we are representing the victims not from the very beginning. And our locus has been accepted by virtue of the fact that it is or it was on our review petition, Milord, that the Constitution Bench gave the judgment, wherein Milord they considered even Chandralal Sahu interpreting Milord the provisions of the Act. Now, while interpreting the provisions of the Act under Section 4, 3 says that Union of India will file on behalf, but 4 is an exception to it. 4 says that the victims will be heard through their counsel, etc. They have a right to be heard whenever the settlement, etc. Because now the settlement is being reopened. Therefore, it is necessary, my lord, by virtue of the enactment and the 2 judgments which have been given, that the persons who are there, I am not talking, my lord, we are not people who have come just like that, my lord. We are there from the beginning. I have prepared a dates, my lord, and all the proceedings in which we intervene, as far as we are concerned, my lord, from the very beginning. So, my lord, I am not going to the merits part of it. I am saying, my lord, it is necessary that we should be implemented and heard in the interest of justice, so that, my lord, it will not be that the victims are not heard. The settlement took place, and at this juncture, when it is very, very necessary, the victims, my lord, because we will be able to assist this honorable court, my lord, to a very great extent in arriving at, my lord, the just kind of disposal of the matter.
But may I
My lord, may I only one thing? We have.
See, what is happening is, Mr. Jha,
It's,
you argue in the beginning, you argue in the end, then you argue something. This can't go on like this.
My
This
lord-
is exactly what we will not permit in the proceedings which will take place.
Yes.
My lord, I was
Uh,
finishing it.
You have to have a disciplined proceedings. It can't be like this that today we have a little time. So you're going here, there, somebody's coming in, somebody's going out. It can't go like this. No.
My lord, the last thing is that the specially petition which we filed, I just pass on the order. That may also be tagged with this
We are
thing.
not here to tell. We
May
are
I-
hearing a curative
May I
petition.
give not the order which was passed in the TP, which was a connected matter, where implement was declined, or and may I just pass that order that's listed? Please, can you pass? it?
may only have a few minutes of your lordship.
You will have the last say. You had the first say, you'll have the last.
I know, I also want to gather all the thoughts.
But this is an order, but there is a petition pending in the High Court. The union has filed a transfer petition to get the writ petition brought here. This is an order in the transfer petition, which is connected to this batch of matters. It's the last in today's this slot. And kindly note, heard learned counsel for the applicants and learned senior counsel for respondents. Applicants Bhopal Group for Information and Action will be heard before any orders are passed in TP, but will not be added as a respondent. That is the order passed in the connected matter. That TP is also listed in today's cause list. That's 502. 502 lot.
We have no objection.
Item 502 lot.
No. You have had your say.
But so what I'm saying, today the fact is twofold. On the one hand, no curative by them. On the other hand, the rules say the first thing.
I've understood.
That's all. I'm not going to repeat.
Yes, certainly.
No, I didn't. It's entirely the discretion of the court as to who shall be heard. But today, after several stages, the initial stage, of course, everybody had a right to be heard. There were several concerns, several ways of, presenting perspectives on this matter. And speaking for myself, we're all gone through this. I had an opportunity of assisting Professor Bakshi in the early stages of litigation. We have gone through representing victims on the one side and also government on the other side. I have fairly a good view of the unfolding dimensions of the case. So at the early stage, everybody heard. I don't want to be heard today saying stifling, but it's right to be heard. I don't like that. Stage where the only question for the parents of party concern is either adequacy of compensation to be revisited. If on that question, if last thing everybody need to go, it is an entirely different matter. But if it's a matter entirely between the court and the Union of India, and what parameters we can reopen it, and then how, and then what parameters the adequacy of the compensation can be revisited, is a matter I thought is where the Union of India may have to assist the court in a large measure.
See, they have flagged 2 issues. One, the fact that you never filed a review petition and you came in a curative petition after 19 years. What is the ramification? You'll have to examine. They have never filed a curative petition, filed a review petition which was disposed of.
Sure.
Correct. Now, what is the capacity in which they are to be heard? These are two, apart from any other issue, this will be issues which will arise. As a threshold. Parties. Learning Attorney General has taken a stand before us that the government would like to press its security petition. Good stuff. A number of NGOs seek to be added as parties before us. Correct. Good stuff. On the other hand, the respondents say that very maintainability of the curative petition would have to be examined as it comes 19 years after the judgment was passed and without going through a process of a review application. Good stuff. The persons who filed the review applications on which orders were passed have not filed a curative petition. And the conspectus of the was that we issue the following directions. First, the government would represent the claim of the persons who have suffered, and thus a compilation would be required to be prepared by the Office of the Attorney General and the respondents, which would be the compilation alone to be referred by us in the proceedings. Number two, insofar as the applicants' associations are concerned, we do not give any liberty to file any pleadings, but at the relevant stage, we will see to what extent assistance can be given by the councils, and we do not foreclose their right to be heard by us at our discretion. Next, the joint compilation, we prepare it within, how much time will both of you prepare it?
It will take about 6. We need at least about 4 to 6 weeks to prepare the government. The additional material may have to be scanned and then
No, whatever.
properly.
There's one.
Wait.
Learn to.
No, I know,
to
but-
time limits, we have to learn to adhere to pages.
Uh,
Otherwise, it becomes an indefinite cumbersome process.
My lords, if
Let-
I may
let-
have a
You
last.
can't interrupt in between, sorry.
10 pages.
10 pages would be
Number of
sufficient.
dates.
No, dates are different, submissions are different. Different things.
Not keeping in the number of facts, not then they may take 10 pages. Within 10 pages.
In 10 pages as per.
I know.
Very.
We will keep it once for housekeeping so that we are sure that everything is ready, then only we'll list it.
Sure, Lord.
Otherwise, we don't want to put a time for listing, so we'll assemble to see whether you've done what is required to be done.
Correct, absolutely.
So 8 weeks, synopsis will be simultaneously filed, or how do you want it?
No, we may file it a little thereafter, after the compilation gets ready, because we may have to do some.
Within 2 weeks thereafter?
Yes,
Within 2 weeks.
we may also need to file some additional documents, materials as part of a compilation.
No. Can't be
No,
like-
to,
We are not having a fresh petition to be.
no, to
There has to
present
be
the,
nuances of curative in it.
no, certainly, I understand the limitation to the curative hearing, but then to update what is the current data and analysis of this. So we need to apprise your lordships of what is the current position. It's very important side of
Within
making.
2 weeks thereafter.
Yeah.
Okay. Learned attorney says that with the compilation. I thought you will file a joint compilation.
Yes,
What I wanted you.
But we nominate one of our colleagues who will sit with the attorney's colleague
Then
and make a joint compilation.
says that some documents may be permitted to be filed on record, limited to the updated position at the ground level. Nothing more than that.
My lords, may I have my lords' very, very brief indulgence on the
What
implications?
after the order is passed?
My lords,
We heard everybody at leisure.
my lords, this
Yes, sir.
point has not.
After having done so, sometimes some order goes in favor of somebody, sometimes it's a more restricted order. Having passed that, you have to accept it. There's no persuasion on that.
My lords, my lords,
We've given you a halfway house. We are quite conscious of it, but that's what you get.
my lords, just on this claim, they are only asking for a refund, the union. So the anguish of the Bhopal victims will not be alleviated, my lords. Our
Sorry.
claim is different, which is
Sorry.
why the order was
Sorry.
passed in our favor
Sorry.
in 2011, my lords.
No, we will
I
not.
am not saying anything about the order, my lord. I am only requesting whether we can put, my lord, in 2 pages our
No.
points.
No. We will hear you on the. Be rest assured, when we give you a hearing, we will.
I know, my lord, lordships have said,
You can argue on the basis of what is filed by the AG's office.
yes.
So you can collect it from the AG's office. There is no difficulty.
Of course, our office is always open very.
My lords, this will put us in grave difficulty, but we hope that the union will have due regard under the act to our claims. Because they are just asking for a refund, right?
नहीं बनता नहीं, 9 weeks की आती है। 10 weeks vacation में चला जाए। Settle तो हो गया था।
So 2nd January it will reopen. 2nd would be a Monday.
Second में बोल रहे हैं। है आपके पास? पिछला साल का।
नहीं पिछले बार मुझे डेट देखा ना 31st is Saturday.
Saturday.
1st is Sunday. 1st January is Sunday.
This week वैसे miscellaneous तो है।
2nd week में 2nd and 9, 10, 11 को लगा सकते हैं.
10th
10th को लगा दी Tuesday. नहीं तो morning का
10th January at 10:38.
Lord, I didn't just contact, that may be miscellaneous.
no, that's the 2nd week we are coming.
Second week.
10th January.
10th January.
10th January.
January. Second, we took care of the admission week.
Very grateful, my lord. If you probably in our anxiety had something not more than, but then it was, my lord, because naturally for such a long time, yes. That's
A lot of anxiety with the
Lot of- Now it's over. The